What's going on, everybody? This is Vinny Milletti with Milletti Law, the strongest name in law. My name is Vincent Milletti. I am the founder, owner, partner, principal, managing member, God King, everything over here at Milletti Law. This is another video. It is the end of the year. I don't know well, first and foremost, before we even get started, make sure that you click on the subscribe button on the YouTube channel at the bottom there, or go to the website, or do both actually. Website, www.millettilaw.com, www.millettilaw.com. Make sure you sign up for the newsletter so you're always in the know. You always get the newest up-to-date stuff. So this video was, if you watch my other video, basically it's the end of the year. A lot of our clients are employers, and all of our clients have, a lot of those employers, they have handbooks, and they really should be annually updating the handbook on changes in law. Places, if you happen to live in places like New York, California, Florida, but generally more of the progressive cities. If you happen to live in a more progressive city, you see often employment law changes every single time, almost every year, and it changes often from down to wages to benefits to whatever employees get. So one of the things you want to do as part of your diligence is you always want to make sure your employee handbooks have up-to-date material inside of them for laws and rules that are being passed and guidance being passed and regulations coming down, that it's always up to speed, because that handbook will protect you at some point in time if there are any issues with employees. So now in the other video, we had something about California. We do function in New York, New Jersey, California, and Florida. We're licensed for those places. So we do function in all those areas there. So this one's about New York. Certain issues came up with employer clients, and I just really kind of want to just go through it. I thought it would be helpful for everybody here. First and foremost, when it comes to final pay, so an employee is separated, right? So whatever it is, you don't like your employee, you and your employee don't get along for whatever reason, you and your employee separate from employment. He separates from employment. You sever the relationship. So what do, right? The first thing you do is you give the employee a letter, just a very generic letter. Hey, Bob, just letting you know on behalf of Milletti Law that your employment is hereby terminated as of, December 30th. Please note that any benefits that you currently have will no longer exist after today. We wish you best of luck in all your endeavors. Something similar to that, something easy that meets the statutory requirement. You have to have that out in 5 days. Final pay. So the rule in New York is on the New York Labor Law, Section 191. The rule in New York is every employer shall pay the unpaid wages not later than the regular pay day for the pay period during which the termination occurred, as established. So that is a lot of language, basically just to let you know that if paydays are Thursday, they are paid on the following Thursday for all wages that are owed, all wages that are due. So let's talk about, now with that, what do you do with PTO? What do you do with sick leave? If the employee has earned vacation time, it really depends on the handbook policy. If your handbook says you pay it out, you pay it out. If it says you don't, you don't. You don't need to, even if it's vested, if your handbook clearly states that you're not going to pay out on employment benefit, you're not going to pay out on PTO, then you're not going to get paid on PTO on termination, whatever the case is. So generally speaking, courts are very generous. So if this were to be litigated, the court will try everything in their power to extend that courtesy to the employees. But if your handbook is clear, no, you don't get paid out on PTO, no, you don't get paid out at the end of the year, you lose your days or whatever the case is, and that's what happens, which is absolutely fine. The employer has their rules, the employee needs to be cognizant and pay attention. Okay, so now we go to the third portion, commissions, right? So this is something that came up recently. Keep in mind, commissions are part of salary. Commissions are part of earned wages. So generally speaking, if you're an employee, you earn commissions, you get paid on your final pay, just like you would get any other salary payments. When it comes to whether or not a commission is earned, the general rule is always look to the handbook, right? In New York, all commission policies are supposed to be in writing and signed by both the employer and the employee. So this really shouldn't be a question. If there is some kind of question, the code and the common law has 3 specific items. 1, it looks to the written agreement. 2, if there's no agreement, it looks at any expressed or implied condition. In other words, if you give commissions 2 weeks after every sale, then that's your implied commission, your implied agreement, your implied policy. If there's really nothing in place, there's no policy, there's no consistency, then the case law is going to apply a standard at the time that the employee produces a ready, willing, and able purchaser. So I don't know, you're a car salesperson, and you sell a vehicle. You have no policy in place to determine when your commissions are set. If you get terminated, and the question is, when do you owe that commission? If there's nothing on the books and it's just a common law rule, it's going to say at the time that the employee produces a ready, willing, and able purchaser. So that's all that is to that. Very cut and dry. So don't worry about it. Okay, so we're just going we're continuing to go forward. Just basically the top three pieces of guidance here are: one, you terminate the employee, give them the letter. Two, you make the final payment has to be at the next pay period. Three, commissions are considered wages if they're vested and due. That should be a very clear explanation. And this is just going to go into the fourth point. It's because contracts in New York need to be in writing when it comes to commissions. So commission agreement, employees who are commission-based employees need to have a written agreement. This is required under Section 191, New York Labor Law, Section 191, 1C. This is the law that requires employees to have written, signed, and executed commissions agreements with their employers. Both parties sign. Has to be on file for at least 3 years. These agreements need to be discussing wages, whether they're wages, salary, whether it's draws, how the money's earned, how it's calculated, what's recoverable, what's not, what's vested, what's not. It needs to be specific. And, just keep in mind that if the employer doesn't have a signed written agreement for the commissioned employee, they're not going to be penalized or anything like this. They're not going to be penalized, but what's going to wind up happening is that the presumptions are going to be in favor of the employee. So employers need to understand, and this is why you always want a handbook. Handbooks are not contracts for employment, but what they do is they set a presumption for the employers when you're in court. They protect you down the road, and they essentially fill in certain gaps, or whatever the case is. They give you the presumption of an innocence, a business judgment rule, or something to that effect that could prevent getting into trouble later on. So just keep that in mind. It's an important thing to have, much like a handbook, commission statement, signed, executed commission statement is very important to have. So I hope this was helpful. I will continue to drop some of these bombs every now and then. Remember, end of the year, check your handbooks, make sure your handbooks are right. If you want Milady Law to do it, we're more than happy to help you. And read through your books and see what's going on there. But yeah, keep that in mind because, again, this is a great way to protect against some litigation that's unnecessary and unwanted. So obviously we wish you all the best. Have a wonderful New Year celebration. Hopefully you had a great Christmas holiday, and we'll see you later.